Hello friends, welcome back to this channel. This is the second part of the chapter Prospectus and Allotment of Securities. In the previous video, we have discussed the provision related to section 23 up to section 30 of this chapter. I hope the video was helpful for you and you completely understood all of the concepts. And this video is the continuation with such video. Rather, you can say this is the part 2 or session 2 for Prospectus and Allotment of Securities chapter. In this particular video, we will going to revise the section starting from section 31 up to section 40. And in the third session of this chapter, we will cover the last two sections, which is section 41 and 42 of this chapter. I hope this plan is suitable for all. So, without a further delay, let's get started. The first section of today's discussion shall be section 31, Shelf Prospectus. The keywords is already presented in terms of your visuals. Let me clarify one by one in general meanings. First, what is the definition of shelf prospectus? According to law, shelf prospectus is a kind of prospectus or is a kind of issue document which can be issued by the company once at a time, and in exchange of such issue, company shall be permissible or company shall become eligible for making subsequent issues more than which consist of more than two times in a particular period of time. Basically, what I have said, company will issue a prospectus which is known as shelf prospectus once in a year, and in exchange of such issue, the company will be eligible for creating multiple issues on the particular year. I hope the meaning is very clear to you. So the next question is can be arise that what are the who are eligible for such issue? So the answer shall be the company who are prescribed by the SEBI or who are under surveillance of the SEBI. It means listed companies shall be eligible for issuing shelf prospectus, and the validity of the shelf prospectus shall be 1 year, 1 year starting from the date when the first issue was made or first offer was made. Next, what do you mean by subsequent offer, or what a company need to do on the time of subsequent offer? As we discussed, in the case of first offer, company issued self prospectus and issue its first tranches of its offerings. Now the company is by law prescribed that it can issue multiple tranches or multiple issues which shall be more than two in a particular year. And in this particular slide, we are just going to understand what compliances need to perform on the time of subsequent offer. So the company need to prepare information memorandum document which shall be prepared under the format of PAS2. This is the e-form number. PAS2 shall be the e-form number, and the information memorandum shall be prepared based on the PAS2. Now, the same shall be issued along with the subsequent offer. However, before launching or before issuing the subsequent offer, such information memorandum shall be submitted or filed with the ROC at least 1 month prior the subsequent issue. what shall be the content or what shall be the things which need to incorporate under the document information memorandum. Company need to specify all of its charges which are updated after the first issue. Such updated charges shall be mentioned properly. What are the net changes occurred in the financial statement or financial position between the first offer or previous offer uh, and before the next offerings? What are the net changes in the financial position? The same shall be disclosed, and any other changes occurred in the backbone of the company, then the same shall be disclosed properly. Next, let's assume a situation for understanding the refund in case of subscribers. Let's assume that once a company issued shelf prospectus and declared that the whole issue will cover in subsequent tranches or subsequent offerings, then by evaluating the internal matter of the company by a particular subscriber, let's assume or let's say Mr. X. Mr. X reviewed all documents and pay pay the offered amount for obtaining the shares on the first tranche. Additionally, he also pays several amount as advance, which will be set off in the time of subsequent offer. Now, on the time of subsequent offer, by reviewing the information memorandum, if Mr. X desired that he shall not continue with the particular company and its offerings, then what will do? What the Mr. X will do? So, for that, Mr. X shall raise a issue or shall raise a application in front of the company that he want the refund of such advance money he already paid on the time of first offering, and on upon receipt of such application by the subscriber, for sake of simplicity we assume Mr. X, the company shall be liable for initiate his refund within a period of 15 days to his account from where the amount has been debited by the company. This is a mandatory rule, and if the company failed for generating the refund within a period of 15 days, then the company shall face the consequences. What are the consequences? We will learn hereafter. Correct? So these are the provision of section 31. I hope this is very clear to you. Next, we will starting the section 32 stands for red herring prospectus. Let's assume the basic meaning of the red herring prospectus. Red herring prospectus are to be issued by the company, especially on such situation when the company is unable to identify its total quantum and pricing related to its shares. And for ascertaining the quantum and the price of its issuable shares, the company issues red herring prospectus. Once the quantum and pricing are confirmed from the end of the company, then the same shall be converted into normal or generic prospectus. However, the document issued for creating a red herring prospectus are known as the red herring prospectus. It means the red herring prospectus doesn't include the detailed particular relating to quantum, means how much quantity it shall issue in terms of shares, and what shall be the price of per share of the issuable securities. For ascertaining these two factors, the red herring prospectus are to be issued by the company. Such red herring prospectus are also known as book building offer. Now, what are the process? For issuing the red herring prospectus, company at first draft its red herring prospectus and all other relevant documents as may be prescribed. Then the same shall be filed with the registrar of company at least 3 days prior to the date of issuing or opening the subscription list. Red herring prospectus are to be considered as the same document and like the prospect are to be considered as the same document as a real prospectus or as a general prospectus are there, and the obligation imposed in the case of generic prospectus, red herring prospectus need to red herring prospectus, such compliances also imposable on the hand of red herring prospectus. Now, after ascertaining the quantum and pricing of the shares, we have discussed that the red herring prospectus shall be converted into normal prospectus. And in this situation, if any variation can be noted by the company between the two documents, what are the two documents? One is red herring prospectus and one is normal prospectus, which are going to be issued at last, or which are the final prospectus. If any kind of variation are found by the company between the two documents, then such company shall create a detailed highlight of such variations, by which the readers or the investors may aware regarding such variations. Finally, once the red herring prospectus converted into normal prospectus and the normal prospectus have been issued among the public. Now, after termination of the offer opening period or offer application period, the company shall specify in detail several factors. The first factor shall be how much capital it has able to raise from the public and what are the closing price of per share. And these details are also to be submitted with the ROC after closure of the application for prospectus. Hope this is clear to you. Moving ahead. Next is section 33, which is the abridged prospectus. In the chapter of preliminary, I would refer to go through the definition of abridged prospectus. Basically, abridged prospectus is a crisp version of a detailed prospectus. It means abridged prospectus is a summarized form of a detailed prospectus, right? How can it be summarized? Let's assume the real prospectus or the original prospectus launched by the company is consist of 400 or 500 pages. So abridged prospectus shall cover the whole material of 400 to 500 pages prospectus into 100 to 200 pages summarized format, just like we are summarizing the concepts in a crisp manner. Similarly, the matter prescribed in the prospectus can also be summarized without deviating or without varying the actual meaning of the prospectus. This is called the abridged prospectus. Such abridged prospectus shall be issued among the investors along with the application form. However, in the case of underwriting agreement, if your company is engaging with the underwriting agreement, if your company is providing any kind of offer which is other than public offer, or if your company issuing share to its existing subscriber or members, then the concept or the provision of section 33 is not applicable. These three factors, one is underwriting agreement, engagement in the underwriting agreement, second is not issuing public offer, and the third is issuing to existing members. In the context of three kinds of issues or three kind of events, the concept of section 33 shall not applicable. Otherwise the section 33 shall. Now moving ahead towards the next section, which is section 34, criminal liability. Now let us understand at first when the section 34 and its liability in attracts. Let's assume a company issued its prospectus and other relevant documents. After verification, it has been found that the prospectus contains several statements which are false or which are misleading. It means which are wrongly influencing. And moreover, the person who authorized the issue is aware of the fact that the same consisting of several falsified statements or misleading statements, and by knowing the same, he issues or he authorizes the issue. In this case, such person and the such company shall be liable to section 447, which is punishment for fraud. And in this way, the company and such officer in default shall be liable to section 447. However, there are several exceptions to section. For example, let's assume the statement which are falsely inserted on the prospectus is immaterial. Then no liability shall be attracted under section 447, or the person who authorized the issue has reasonable ground to believe that the statement actually false. However, the approving authority understood as the statement was correct, and hence they approved the statement. Then no liability shall be attracted, and such kind of misleading statement were necessary for inclusion, or such kind of false statement, such kind of true statement were necessary to exclude in certain cases, by which the true statements were excluded or falsified statements were included. In this section, in this situation, the liability of 447 shall not be attracted. If you have any kinds of doubt, I would suggest you to review the actual ICAI module or any kinds of reference books which you have. Next, moving ahead. Next section is for section 35, which is civil liability. Let's again understand the mode of the point of attraction. First is any individual or any body's corporate as a person subscribed for the particular prospectus or the shares, and such prospectus or other issue document consist of several misleading informations, and after subscribing such prospectus or such shares, the person who has subscribed faced sustained loss, faced losses and having significant losses. Then the liability under section 35 will be attracted. Next, what are the who shall be liable? The directors, the authorities, the promoters, and the experts shall be liable for such kind of fraud, and in the for such kind of misstatement. And in case of fraud, the liability shall be considered as the unlimited liability, and for section 447 shall be attracted. I hope this is also clear to you. Moving ahead towards the next section. Not towards the next section, there are several exception to section under section 35, which is if no, which is the provision of section 35 shall not be applicable in the following cases. The first case is the director provided its written consent for issuing the prospectus, and before issuance of the prospectus, the director withdrew the written consent. Then such director shall not be chargeable for section 35. Next, the director issued such written consent without knowledge, or if issued and the same is visible in front of public, then the company issued another public notice in terms of newspaper advertisement for spreading awareness. Then the section 35 shall not be attracted, or expert statement have been issued against such prospectus which properly representing the true and fair view of the statement, and the same has not been withdrawn. Then these are the exception to section for section 35. I hope this is also clear to you, and if not, I would recommend to review from the ICAI official material and or any other reference book you have. Next, moving ahead towards the next section, which is section 447, which is punishment for fraud. Now, let's assume a case the amount of fraud is exactly lower of rupees 10 lakh and or 1% of turnover. It means first we need to check rupees 10 lakh and 1% of turnover, whichever is lower. We have an amount. Let's assume rupees 10 lakh is the lower amount. Now we need to compare the amount of fraud is equivalent to 10 lakh or lower than 10 lakh. If the amount is equivalent to 10 lakh, then the first bullet point shall be applicable. The public interest, if the public interest involved, if no, then imprisonment shall be 6 months to 10 years. However, if public interest is initiated or involved, then the imprisonment shall not be less than 3 years up to 10 years. And provision, it means imprisonment as well as fine, both shall be chargeable, not or. Next, the fine is 3x amount. It means the if the amount of fraud is 1000 rupees, then the fine shall be 3000 rupees, right? 3x of the amount of the fraud in both of the cases. Now, let's assume the lower amount shall be 10 lakh and the amount of fraud is less than 10 lakh. Then public interest basically not involved in these cases. So public interest not involved. Imprisonment shall be last up to 5 years or provision exist here and the fine shall be up to rupees 50 lakh or both. It means the provision of or shall be rewritten as and shall be rewritten as and because in the context of fine it has been written the amount of fine shall be 50,000, sorry, amount of fine shall be 50 lakh rupee or both means you may incur imprisonment or fine as well, correct? So in this area the provision or shall be rewritten or shall be pronounced as or. I hope this point is also clear to you. Next, moving ahead with our next section, which is section 36, punishment for frequently inducing person to invest money. Basically, this particular section is framed for such kind of person or such kind of entities who influencing general people or general public deliberately for the purpose of generating own benefit by providing falsified informations. Therefore, according to the section, if any person either knowingly or recklessly means either he influencing a particular people or particular person either knowingly or recklessly making any statement or promise which is false in nature or deceptive or misleading, which is false or not relevant or misleading means such information may lead to such person into a wrong turn. Then the further the statement provided by such person is a deliberate in nature which conceal the material fact means which restricting the material facts and such other person or the opposite person got influenced or uh, got inducted by such other person for which purpose they will be inducting for subscribing acquiring disposing underwriting securities or for securing profit was the main purpose means the person want to secure his own profit is the main purpose. Next, for obtaining the credit facility from any bank or financial institution, the person of want to obtain credit facility from any bank or other financial institution, then such kind of person shall be liable for punishment under section 36. The provided visuals is the keywords in this particular point. I would recommend to review once again with the key points. Now moving ahead with the next section, which is section 37, class action suit by affected person. So basically the provision of class action suit is discussed under this particular section. Let's assume a particular situation where a group of people, not a single person, where a group of people filed a petition from respective areas or in a particular area against a person. Now now as the suit has been filed by more than two persons by more than one person as a petitioner acting for a particular suit, the suit shall be called as class action suit. Detailed provision you should read from the study mat of ICAI. Basically, this kind of questions related to section 37 is quite often in examination. So be prepared for upcoming examination by referring the ICAI material. I just tell you the actual or the core conception or the meaning, you may say, what is the definition of class action suit in general parlance. Okay, next, moving ahead with the next section, which is section 38, punishment for personation for acquiring, etc., securities. Person shall be liable. Under section 447, if a particular person submit an application which is not actual or which is not based on real data. Second thing, the person applied the person itself applied several applications, which is more than one, by using different name or combinations. And thirdly, the person otherwise induced directly or indirectly other person for allotment or registration of the shares in a fictitious manner. Then in such situation, in such situation, the person shall be chargeable under section 38. Now, in case of prospectus or form of application, this kind of caution must be read or must be reproduced, means must be written properly. On the time of conviction, the convicted person shall be liable for disgorgement of the gain, and such amount of the disgorgement shall be credited to IEPF account. On the time of reading or on the time of discussing declaration and payment of dividend, we have read that the main sources or the main inflow in the IEPF account was one of the source, which is disgorged funds or disgorged gains. I hope this is also clear. Moving ahead with the next section, section 39, which is allotment of the securities. Next, up to section 38, we just read the provision related to the prospectus, issuing of prospectus, and contravention if any kinds of contravention have been made on the time of issuing a particular prospectus. Now, in from section 39 up till section 40, or you may say section 41, we just read the area of allotment of the securities, and the section 42 shall be encrypted with private placement, which is completely different concept. Next, section 39 is allotment of the security. First of all, the company shall provide a prospectus. As we read earlier, the prospectus shall have a opening date and the prospectus shall have a closing date. After expiry of the closing date, the company shall close the application immediately and forthwith check two factors. First is written on the kind of orange box. First orange box I am referring currently. The company will check two aspects. First is whether the company received minimum subscription amount as it desired or as it retained formally in its prospectus. This is completely depends on the articles of association of the company or the company's view on the time of issuing the prospectus. If yes, then the company need to check whether minimum application money, which is formally 5% of the nominal value, is received or not. If two conditions get satisfied, then the company shall proceed with the allotment process. Otherwise, the company need to refund the whole money taken from the respective persons. Next, next question may arise, in which terms the company may receive the pay. The company must, this is the provision, the company shall receive, not may. The company shall receive its application amount in terms of check, in terms of NEFT, or in terms of other instrument which is prescribed by the RBI, which is called electronic instruments. The same shall be the mode of transfer. Now, the third box, mentioning that the application money received by the company shall be deposited in a scheduled bank, and separate account shall be maintained for such application money, and the application money shall be only used for the purpose of either allotment of the securities of the company or refund to the investors. Next, under section 39, we have several more things, which is before allotment, the company the company must file PS3, the return of allotment with the ROC. Before allotting among publics its shares, the company need to prepare its return of allotment in the format of Pass 3, and the same shall be deposited to the office of the ROC. This is the basic information which ROC obtained, that how many number of people and who are the exact number of people subscribed for the particular prospectus ultimately. What shall be the content in the pass 3? The content in the pass 3 shall be name of the shareholder, number of his shareholding or percentage of his shareholding, and the allotment and the data related to the whether the allotment is made other than cash or not. Means the allotment shall be, if the allotment shall be made in exchange of cash, then the whole matter shall be okay. If not, then rule 12 will prevail. Next, what is mentioned in the Rule 12? Rule 12 is teaches us or is providing guidelines related to how can we prepare the return of allotment. In the case of Rule 12, the as we discussed earlier, within a period of 30 days, the pass 3 shall be submitted with the ROC. The shares, if issued other than cash, then the copy of the contract or stamped copy of the contract shall be provided with the ROC. If no such contract for sale have been mentioned or exchange contract have been written, then the stamped particular of contract shall be provided with the office of the ROC, along with a copy of valuation report which is prepared by the registered valuer in the case of allotment of shares other than cash. It means you can take as example in this case particularly, like the company X purchased a particular plot from Mr. Y, and in exchange of providing cash of such particular plot, the company issued say, equivalent number of shares to Mr. Y free of cost. So this is issuing of shares or allotment of share other than cash. Next, in the case of bonus securities, the copy of the resolution shall be passed in the general meeting before issuing the bonus securities. In the case of share issued under section 62(1)(c), which we'll be reading on the chapter share capital and debentures, share issued under section 61(1)(c), the valuation report by registered valuer shall be required. Next. Next is in the case of refund. Rule 11 refund of application will guide us how a particular company initiate refund for a particular with respect to a particular investor. In this situation, after closure of the application or after closure of the application, the company will start its process of application or allotment. Correct? The company will start its allotment process. After termination of allotment, company may or may not provide the shares to everyone, and for the purpose, the person or the investors or the applicants, you may say, who are not received the share of the particular company, the company, after the expiry of the application process, allotment process, forthwith within a period of 15 days, company shall initiate the refund requests and spray its refund amount to respective accounts. If not done, then 15% per annum interest shall be imposable on account of the company. And who will take the liability for interest? The officers in default, either jointly or severally, shall be liable. It means the director shall be liable. I hope this section is also clear to you. So next, moving ahead with our next section. This is one part we have left for section 39. which is in case of default. It means the company may default in any area of section 39, then such company shall pay or such liable to pay rupees 1000 per day basis up to 1 lakh rupee for each default. This is section 39. Now, the last section for today's video is section 40. Securities to be dealt in the stock exchange. It means before issuing the prospectus, the particular company desired to list its equity share on any kind of stock exchanges, whether it may be Bombay Stock Exchange or whether it may be National Stock Exchange in India. For doing this, before making any public offer, company shall apply to one or more. This is up to on the hands of the company. If the company want to raise application in one stock exchange or both, then it can do so. However, company may apply in the respective stock exchanges and obtain their permission for listing. And if application made on the recognized stock exchange, then company need to make sure one thing, that the application got approved from the respective stock exchanges, from every stock exchanges on which it made application. Let's suppose in this point, in India there are basically two prime stock exchanges. The company applied in the company applied both of the stock exchanges. However, the NSC approved the application of the company. However, the BSC rejected the application of the particular company. In such situation, the question is whether the company proceed with its public offer, as it has got approval from one stock exchange out of two. So the answer shall be no. By law or as per the law, how many companies, how many stock exchanges the company has applied, the company has the liability for obtaining positive feedback or positive approval from each of the company. Sorry, for from each of the recognized stock exchange for issuing its securities on the market. This is the exam question which I have discussed right now for explaining the middle point or the point mentioned in the green box. Next, amount of the application money shall be used for only two purposes. One is adjustment towards allotment, means the company receive the amount and allot its respective share with the respective face value, and the refund purpose. If it unable to allot its shares among the public, then it should refund its equity shares. Next, Rule 30, payment of the commission. In the case of share, 5% of the issue price or AOA, whichever is lower. WIL is mentioned as whichever is lower. In the case of issuing of ordinary shares, the rate or the rate of the commission shall be lower of 5% of issue price or AOA. And in the case of debenture, the rate of commission shall be half of the 5%, means 2.5% of the issue price, and the AOA as it is mentioned, whichever is lower. Next, no commission if in the case of offer which is other than public offer. In the case of public offer, the company is eligible for issuing the commission or paying the commission to the underwriter. Otherwise, no commission shall be payable. The several contents or several facts shall be disclosed. First is the name of the underwriter or the name of the underwriters, the percentage or the rate of commission the company has paid, the number of securities they have allotted for the purpose of public issue. This kind of data have been are required to be furnished or are required to be disclosed. Next, copy of the contract with the made with the underwriter shall be delivered with the office of the ROC along with the prospectus for which such underwriter have been contracted. Okay. Next, in the case of default, the fact is very simple. Two persons shall be liable. First is the company and second is the officer in default. Company shall face a minimum 5 lakh fine and a maximum 50 lakhs rupees fine. In the case of officer in default, they will face 50,000 minimum fine and they will 3 lakh rupees maximum fine. I hope this is also clear. And yes, with this, the today's video come to an end, and I hope this particular video shall help you or will help you rather while understanding the chapter prospectus and allotment of securities as we promised. There are two more sections are left in this particular chapter, which is section 41, global depository receipts, and section 42, which is private placement. These two are the crucial components of this particular chapter, which is especially section 42 is very crucial in this particular chapter. So the two videos shall be covered in a separate video in future. The date of such video shall be discussed earlier. First of all, you should what you should do currently or what you should right now. If you haven't checked out the first video of this particular chapter, which is section 40, 23 to section 30, I would recommend to visit the I button or visit the description of this particular video and retrigger to such redirect to such video. Complete that. After that, come to this video, complete this one also, and after that you should open your questionnaire, do some writing practice, and with this your writing speed and your writing pattern or addressing a particular question shall be addressed. If you have any kinds of doubt related to the writing pattern, then you should comment down, and based on the majority of the comments we will also cover the particular video where we will be discussing how can you write effectively in the exam by which you can score a maximum marks. I hope this video is very clear to you and helpful to you. If you record such kind of video, then do comment. Based on your comment, which can be majority, we will prepare another video. And do like this video if you actually liked, and you can hit the dislike button, but you need to mention the exact reason yes, the exact reason why you disliking this particular video in the comment section or the mail id we have provided here under, by which we can motivate ourselves or we can improvise ourselves. Correct. So yep, that's all. Have I am your instructor Shantan Jana signing off for the day. Have a good time ahead. Thank you guys.